We are on the record in the matter of City of Wyandotte versus Vanessa Bell, 24725.
Crystal Marie Medina, Your Honor, on behalf of Ms. Bell, standing in for my MIDC colleague, Mr. Serrano. Ma'am, would you please say your full name for the record?
Vanessa Bell.
All right, good afternoon. And so this matter was scheduled at 2:15, and so at 2:40, this court called the matter and issued a warrant. Mr. Serrano has since left, and then I was informed that you arrived.
And Your Honor, we would ask that that warrant be set aside. My client did advise me that she was actually at the hospital. She did indicate that she had documentation as to that. Is that correct, ma'am?
Yes, I have a moment.
I'll take a look at the documentation, please.
And Your Honor, for the record, I hadn't reviewed it for myself because I was honestly hesitant to grab it.
You have not reviewed it yourself?
No, I was hesitant to grab any paperwork from the file, to be honest.
Well, ma'am, I have to say, I'm kind of curious as to how your visit to the hospital on December 28th caused you to be late today.
I have pneumonia. It's hard for me to breathe. My mind isn't clear. I'm sick. I'm moving very slowly. I'm extremely stressed, and it slowed me down today. I have pneumonia. I'm real sick right now.
Can I see the paperwork now, please, real quick? Ma'am, you made it appear as though you were just in the hospital today, and that's why you showed up late.
I said I was very sick. That's why I'm late, because I was running late because I don't feel good, and my head is not clear because I'm extremely sick, and it caused me to be 20 minutes late.
Am I missing something, or does this say?
Maybe I didn't give you all the right paper because I have I did a lot of medical. So she said there's been something missing, so I may have not given her the.
This just tells me, ma'am, that you have development of patchy bacillar infiltrates. That's not pneumonia. I'm not suggesting that it's not something, but it's not pneumonia. So here's what ma'am, this appears to be a delay tactic. Because, ma'am,
It says right here.
ma'am, you were at the hospital December 28th is when, well, you had that imaging done December 28th. I don't know if it was from the hospital. I don't know if you were ordered from your doctor and you went to an imaging place. I don't know. But what I do know is December 18th, the final pretrial was held. We adjourned it for one final time to today's date at 2:15 because you wanted to retain counsel. We have not yet received any appearance from any attorney.
I have Mr. Friedman, and I had a hard time getting a hold of anybody during the holidays, but I did try to talk to Mr. Friedman yesterday, and he has asked me to obtain the transcripts from the motion and a few other things that he can look over so he can decide if he wants to be my lawyer or not. I mean, I'm very sick. I have pneumonia, like it's a development of patchy, whatever, that I have pneumonia.
Well, that says that it's a condition caused by a partial collapse of your lungs.
A partial collapse of my lungs. And that's not serious.
Yeah, I didn't say it wasn't serious. That's not what I said.
Right, but that prolonged me from doing the things that I had to be doing. On top of the fact that it was the holidays and nobody was calling me back. I called probably about 30 lawyers. And I finally had Mr. Freeman call me back yesterday. And Mr. Freeman is going to take my case. I just have to give him information. And I mean, I'm doing the best I can. It's not my fault that the lawyers keep quitting on me. I'm not firing them.
No, ma'am, that's not accurate. That's absolutely not accurate. You asked, you have stated that, so there's been Mr. Goldpaw, you wanted a different attorney, there was a breakdown, the attorney-client relationship.
Yes.
And then the same thing happened after Mr. DeBlois, after the court denied the motion to dismiss, and then you wanted to, you and Mr. DeBlois didn't see eye to eye or what have you, so you wanted to retain counsel.
Mr. DuBois actually he sent me an email telling me that he was no longer able to be my attorney. He quit on me. Okay, and the first the older gentleman, he also said that he put in the motion to suppress. He said, I cannot be your lawyer anymore though.
Okay, ma'am, I'm not going to get into why, whatever the breakdown was between you and the attorneys or the attorneys and you, I'm not going to get into that. At the end of the day, this matter has been pending Since June.
Yes.
Since June. So, there has been final pretrial after final pretrial after final pretrial. So, I was very clear, the last date you were here, that this was going to be the final adjournment. So,
And how would I be aware that Mr. DuBois was going to stop being my lawyer?
I'm sorry?
Mr. DuBois didn't even tell me until 2 days after, at the last time I seen you, that he was going to step away from being my lawyer.
Yeah,
So-
on December 18th, there was a final pretrial held. Mr. DuBois made an oral motion to withdraw as counsel to represent you, which this court granted. Then you had asked for an adjournment so that you could retain counsel. And I stated, we will adjourn until January 5th at 2:15. And that was the final adjournment, and that was so you could retain counsel. So now, here we are on the 8th of January, and there has not been an attorney that's filed an appearance on your behalf. And you were not here at timely, it was almost half an hour before you appeared. And you're now asking for another adjournment, because you want transcripts or whatnot.
This is what Mr. Freeman had told me that I needed to get in order for us to start, because he obviously has no idea about the case. And I told him about the motion being denied, and I said that I wanted to appeal it, and so he said he needed the transcripts and he needed to do some things, and I have to sign a retainer. I just spoke with him yesterday at 4 o'clock. It was the first time I spoke with him, and I didn't think I thought I was going to come today without a lawyer at all. I cried uncontrollably for 4 days. I know that doesn't matter to you, but this has been very stressful for me. I understand it's been since June. I want this to be over with too. Okay, I am over this too, but I feel like I have a right to stand up for my civil rights, which were violated. I believe 100%. Okay, so these lawyers, they're quitting on me. Okay, so I have to find another one. First of all, I had to come up with the money. Okay, that was hard, but I did it. And then it's the holidays, so nobody's calling me back. And even though I was very sick, I still continued to work my butt up to get a lawyer. I am working my hardest to make sure that this is taken care of in the way that I feel appropriate for myself. I have been trying very hard. I have come in here with nothing but respect. And yes, I was late today because I am beyond stressed. I'm super sick, and I was forgetting this and I'm forgetting that. And I tried my hardest. I've tried my hardest to do nothing but respect this court and do everything that I believe for myself is right. And I needed my own lawyer, and I finally found one at the very last minute last night. I have called and I have done everything
So,
I can.
Mr. Friedman does not have an appearance filed here yet.
I understand that. I just spoke with him yesterday at 4 o'clock. And he isn't even sure if he is able to take my case. I have to give him more information. Okay, I understand that this is taking a long time, but there are things that keep preventing me from moving forward because I keep having to get a new lawyer, which has to catch up on the case, which has, this takes time. I mean, I have a right I have a right to do this. I have a right to make sure that
you do, but let me also clarify this. You've had a right to retain your own attorney since June.
I understand that, and I couldn't afford one. And then when I came up with the money, I worked my butt off. I wish I had my phone so I could show you how much time and effort I have put into finding my own lawyer.
Ma'am, that's fair, and that's fine. I can also show you how many times this matter has been adjourned to allow you that opportunity, to allow motions to be filed and such. And so here we are now, 7 months later, there's no talking in court. 7 months later, and we're not any further along.
I understand that, and I was okay with Mr. DuBois. I had no problem with him being my lawyer, and he decided that he couldn't represent me anymore. And so I needed time to get another lawyer, and this lawyer has to catch up with my case, and I am entitled to a fair process.
Which is not, ma'am. It's been a fair process. The court has afforded you.
But it hasn't though.
Excuse me. The court has afforded you a number of opportunities to hire an attorney, to have motions filed. You've had now the third attorney appointed to represent you in this manner. I am giving you 1 month, ma'am, because at this point the case is already over time standards anyway. What's 1 more month? 1 month. That is it. I am not giving you one more adjournment. If you do not have your attorney, or you do not have whatever needs to be had, this is being set for trial.
I appreciate that.
That is it.
Thank
I
you, Your Honor.
appreciate that, thank you.
Thank you, Your Honor. Okay, ma'am, so just reach out to him, get with him.
So it's going to be scheduled for February 5th at 2:15 p.m. Don't be late, ma'am. If you're not here at 2:15, a warrant will issue.
I will be here at 4:45.
And I will say that it appears as though you made it seem as if you were in the hospital right before you got here.
That was my
Okay.
impression, Your Honor, when she said, here I have hospital records to show that I'm sick. Obviously, Your Honor, yes, logically you would think, since that was the reason we're talking about her being late, yes, that's what I thought, Your Honor.
If you're in a test, ma'am, right now, what's in your system?
Absolutely nothing.
Bond and conditions are continued. We'll see you back on February 5th.
Thank you, Your Honor.
Yep. Okay. Go!
Will you hand me my scream box?
Now go. Preach.
All right, we're on the record in the matter of the city of Wyandotte versus Vanessa Bell, 24725. Good afternoon. Your name for the record, please.
Vanessa Bell?
Okay, so, ma'am, where's your attorney?
I was told that I was just gonna get a court appointed.
You said that you
No,
were
I-
retaining, Attorney Friedman. On January 8th,
Yes, and he never called me back.
excuse me, on January 8th, you didn't appear on time, you appeared late. The court set aside the warrant. Then you indicated that you had Attorney Friedman that you were going to be retaining, that he was representing you. And he said to request an adjournment. So this court granted the adjournment despite not having an appearance filed by an Attorney Friedman. February 5th, you were scheduled to be here. No appearance filed by Attorney Friedman. The court ordered immediate warrant issue. However, you did send in supporting documentation that you were ill and in the hospital, so the warrant did not issue. Yet we don't have an appearance by Attorney Friedman. Did you retain the services of an attorney named Friedman?
He told me that he was going, that it was going to be a certain rate.
Ma'am.
I couldn't afford him anymore. He upped the price. No, I did
Ma'am,
not. I
my
did not.
question is yes or no,
No,
okay? Yet you told this court that you were retaining this Attorney Friedman.
yes, that's what I was aware, that's what I thought at the moment, yes.
Okay, well, ma'am, looks though you're gonna be representing yourself because you have gone through all of this court's appointed attorneys.
They quit on me. I mean, there's nothing I can do if they quit on me.
Ma'am, they didn't quit on you.
Yes, they did.
There is a breakdown in attorney-client communication. There was apparently some difference in approach to the case. And so then those discussions went south. And so I believe you have not, let me see here. You have had, first of all, this matter has been pending since June.
Yes.
That's when you were first in custody and arraigned. Let's see here. There was, on September 18th, an oral motion for the attorney to withdraw, that was granted. And then Mr. DeBlois was appointed to represent you. Mr. DeBlois did so, and then filed a motion as well. An evidentiary hearing was scheduled on December 4th. That motion, the evidentiary hearing, the motion was denied. And then on December 18th, a final pretrial was held, at which time you said you were going to retain counsel. And Mr. DeBlois' oral motion to withdraw was granted. You, in fact, did not retain counsel, clearly, because the attorney did not file the appearance on January 8th, as you stated that he was going to, nor subsequent to that. So you have been through Mr. DeBlois, Mr. Serrano, Mr. Goldpaw, I believe maybe even Mr. Westmoreland.
That was a different case. That was a different case.
I'm sorry, I was still talking. What was that?
That was a different case.
Okay, so we're out of attorneys for you, ma'am. We're out of attorneys. A defendant is entitled to representation to be appointed. However, they're not entitled to continue to have multiple attorneys appointed.
So if they quit on me, then I don't have the right to an attorney, a court appointed,
Yeah.
because they withdrew, is that what you said? Withdrew for me?
There were oral motions to withdraw
Yes.
based upon attorney-client breakdown, okay? Now, we only have so many attorneys that are appointed to work in this court. So, and you stated you were retaining an attorney, twice, multiple times you've stated you were retaining an attorney.
Because I didn't have a choice. If they withdrew for me, I had to get my own attorney.
Okay, so ma'am, in December, you stated you were retaining an attorney. And then on January 8th, you came back to court late, significantly late.
Because I was significantly ill.
And your attorney that you stated that you retained was not appearing and asked and had you request an adjournment.
I was extremely ill, 2 cleft lungs, and I still made it. I was 15 minutes late.
I think it was a little bit later than that, but in any event, you stated twice that you had an attorney that you retained, that you were retaining.
Yes, I had every intention that, and he said 200 or 2,500, and then he went up to 5,000. I don't have 5,000, so I could use him, and I will absolutely fax in all of the referrals of all of the lawyers that I have spoke with. I have been trying, on top of the fact that I'm sick. I'm extremely sick. And I'm still here. You think I want to keep doing this? It's like you said, it's been since June. I want this over with.
Ma'am, I can understand that. Are we keeping you awake, ma'am?
What?
Well, I don't know if we don't have any other attorneys here at this court.
Well, I'm going to continue to try to find an attorney if I have to represent myself, then I will. If anybody knows the case better than anybody beside me.
I will have to chat with our court administrator to see if she can contact the regional office to see if they can send somebody here to represent you. I'm not sure how that works. So if you can just have a seat for a few moments, ma'am, we'll figure out how that works.
I've spoke with 3 of them yesterday, and hopefully one of them will call me back. Like I said, I'm not going to stop looking, but if I have to represent myself, I have no problem doing that.
Just have a seat, please, for a moment. City of Wyandotte versus Vanessa Bell, 24725. All right, so Ms. Bell, your name for the record again, please.
Vanessa Bell?
All right, and so we contacted the regional office for the appointed attorneys. So we are going to adjourn this. I'm going to give you a new date. You have to then notify the regional office, and then they will assign somebody.
Okay.
Okay? So
What is the regional office?
the Michigan Indigent Defense Commission regional office.
Oh, okay.
That's where the individuals that practice in this court for appointed cases, they're assigned out of there.
Oh, okay.
And since you've gone through all the attorneys that are here, well, I don't have any, and I cannot appoint one to the purpose of the MIDC. So we will adjourn this to March 5th, ma'am, Wednesday, March 5th. If you were to test right now, what's in your system?
Absolutely nothing.
Not any medication for your illness either?
Antibiotic.
Okay, we'll see you back March 5th.
Shelli, because we have the, I know that we have it on here first, but we have registered for Gloria here. Their presence was requested because of confirmation, for confirmation purposes of the non-violation, which is, was the alleged defendant didn't show up for testing.
Your Honor, I believe he didn't sign up for testing.
So he claims he went. No, my note.
Oh, that's right, he claims he
went. So my note was for on-site person to be present because there was a dispute as to whether he went or didn't go.
Okay.
So that's why Mr. Fakuri is here.
Okay.
So we're on the record in the matter of the city of Wyandotte versus Joseph Chirelli, 241115. All right, and so counsel, your appearance, please.
Your Honor, John, roll call P30758 on behalf of Mr. Shirley. Mr. Shirley, would you please put your name on the record?
Yes, Joseph Shirley, sorry for my attack on driving. I came right from work, so.
Okay. She said up on statute. And so, today's date scheduled for sentencing as well. Nope.
Section folder.
Yes, it was that close. We adjourned it. And then, the bond violation hearing. And so, the bond violation hearing is alleging that Mr. Charlie did not appear for testing on, December 22nd.
You are, I
And
believe.
Mr. Shirley said he went.
Next stretch out.
And so we have Mr. Corey here to, hopefully clarify a few things. Mr. Fakori, can you please state your name for the record, please?
Jacob Fakori.
So this court at your adjourned pretrial date on December 4th ordered you to test on December 4th.
He never came in to enroll December 4th, Your Honor.
Okay? So Mr. Shirley?
I did go there that day, Your Honor. I do have a picture to prove that. I did not have the $35 that day to pay for my test, so therefore they didn't sign me up because I couldn't pay for my test. But I promise you I was there.
Okay, let me take a look at that photo.
There is an on-site building. So, and then when I couldn't get...
Hold on.
Okay, I'm sorry.
Hold on. Okay. So this is the on-site building. You're out in the front of it. That doesn't tell me that.
I had waited.
Oh, hold on. You're aware that you can slide up and you see the date and the time the picture's taken, correct?
Yes, that's the time I was there.
Right, December 6th at 6:16 p.m.
They told me to come back on Friday.
Sir, you are to be there December 4th, right?
Yes.
Okay. Did you go December 4th?
Yes, I did, Your Honor.
Okay, so where's your proof of that?
I don't have the proof.
Hold on, you just gave me this photo as proof that you were there on the 4th.
I didn't take that photo until I went back on Friday.
Okay. Why didn't you take the photo on the 4th?
I guess it was my mind. I didn't think of it, Your Honor. I don't know.
Well, sir, you were ordered to go test on the 4th.
I understand.
Mr. Corey, did
Yes.
Mr. Charlie appear on December 4th?
No, he did not, Your Honor.
Okay, that's where you're in, Mr. Corey?
I'm sorry?
That's where you're in?
Yeah, he did not, because if he came in, everybody signs in on a walk.
Mr. Corey, hold on one moment, please. Please raise your right hand.
I do, Your Honor.
Thank you. And I'm sorry, what were you saying about if he had come in?
Anybody that comes into our building, the first thing that's done is there's a log sheet for the day. They sign in, and then they put the time that they came in and what they're there for and how much money that they're paying
Okay.
on that sheet.
If somebody comes in and they don't have the money to pay, is their name still on that log sheet?
No, it depends if they came in and left, no. But if they came in and signed in and then said that they didn't have any money, then their name would be on the sign-in sheet. And we checked that and name was not on the sign-in sheet.
May I ask you a question?
Yes.
When an individual comes in to sign in, is there any type of discussion prior to signing in about paying?
Usually when you sign in, then we know what you're there. We need to find out what you're there for so we can give you the proper paperwork and the correct amount to pay.
I understand that, sir. My question was, if an individual comes in and says, I'm here to sign in for testing, does whoever is the receptionist, does that receptionist indicate that money has to be paid on that day?
When they come in, if they say I don't have any money, then we say no, don't sign in. You know, you have to call your PO and come back when you do have the money. But when they come in, we don't know what they're there for till they sign in and we know who they are and you have to make a copy of their ID.
So you just said, correct me if I'm wrong, if a person comes in, says, I don't have the money today, they'll tell then the receptionist, whoever is directing that they sign in, says, well.
Gloria, are you back?
Pardon? Don't sign in.
Yeah.
Come back when you have the money.
They come in before they sign in. If they say, I don't have the money to come in, then we tell them to contact their PO.
Thank you.
Okay, however, Mr. Shirley wouldn't have known if he had what the amount was until he would have signed in. That's what Mr. Pecori even stated, that when they sign in, the testimony was that they don't know what the cost is until the person signs in, fills out the paperwork, and then Mr. Pecori, they can tell whether it's Mr. Pecori or somebody else at the testing site.
Mr. Jordan, are you there?
But
Stop talking, please. You're interrupting the record.
Your Honor, he also said that if somebody says, I don't have the money to pay, then they don't sign in, and he said, you're told to contact your probation officer. So there are times when an individual come in to sign in and then doesn't have the money, knows he or she doesn't have the money, and then follows the further directions.
Okay. So I'm guessing I'm going to be told that Mr. Shirley got there, didn't sign in because he already told somebody he didn't have the money.
They asked me when I got there, I gave them a paper, and she said, oh, how much do you have to pay today? And I said, nothing, I don't have to pay no money. Well, then she looked up and she called I'm sure she called either a probation officer or he or something, and then that's when I found out. She said, oh, you have to pay $35 today. And that's when I said, well, unfortunately, I don't have $35 right now. And then it got postponed, and then something happened, and then that's when I came to you and asked you to switch it to saliva because I was having a tough time going with a guy looking at my stuff. And you switched it for me, and I went that day and took it.
Your Honor?
Yes.
Yeah. When Mr. Sorelli was given the referral from the PO, on that referral, it spells out exactly what the payment would be on it. And Mr. Sorelli, when he came in on the 17th of January to sign up with us, there's some paperwork that he signs that the release of confidentiality for the probation officer, our rules and procedure for successful drug screen, and then the information on the payments that are made, which on the 17th he did. And after he came in on the 17th, he did not show up on the 22nd or the 30th or the 5th. The only time that he came in to tell us was on the 17th, and has not been in since then.
Why haven't you been in, sir?
I had no idea. I had to go back. They told me they were going to call me when my color got called up or something, a black color or whatever, and then they never called me. So I never, back when this was a part of my life, Your Honor, back when I was doing this a long time ago, 10 years ago, I never had to call a place or go back numerous times a month. It was only the one time you go see your PO, and that was it. So this is all kind of new to me, and I'm just trying to figure it out because I don't want to lose my job. I have nothing to hide. I know you guys think I have a bunch to hide, but I really don't.
First of all, I'm not. Sir, first, I'm not banned, and don't assume what it is I'm assuming.
I'm sorry.
So, Mr. Pecori, how was an individual notified from your facility that they need to test?
Once they sign up and they fill out of all the forms, then they're given a log sheet. And on the log sheet, we write down what they did for that day, the date and time, and what they paid. And then at the top of the log sheet, we have outlined 2 phone numbers that we tell them they come up live at 5 a.m. in the morning. And we have 2 numbers just in case, for whatever reason, one goes down, then there's also the second number under a different system that they can call. And underneath that is also highlighted our website to where they can go on the website and it will give them the colors for the day. And we tell him if your color is called, then you need to come in. On his log sheet, across the top, underneath where this information is, his name is on there and the color that he's to call for, black, that's written on the sheet. Everything is pretty much spelled out. There's no thinking involved in what it is that you have to do.
Okay, so sir, did you get copies of that paperwork?
I have received some kind of paperwork, but unfortunately, when I had left that day, I hopped on the smart bus and I left my backpack on there. And unfortunately, all my paperwork and my USW jacket's gone. Like a lot of my stuff is gone that was in my backpack. So what was on that paper, I don't know. I don't know if it said come back or not. I couldn't tell you that.
You didn't read it? You didn't look at it? You didn't contact into the court afterwards? You didn't contact back to on-site?
I was going to read it when I got home, Your Honor. And then when I hopped off the bus by my house, I forgot my backpack on the bus. And by the time I realized it was too late to go back to the bus to get my backpack.
Okay, and when was that, sir?
That was about 3 weeks ago.
Great,
Portland.
okay.
But like I said, I didn't know.
Hold
I had to
on.
report.
Did you call on-site to let them know, hey, I left my backpack with the papers I received on the bus. Can you please give them to me again?
No, I didn't.
Okay, no.
Okay.
You either did or you didn't. Did you contact the information here to say, hey,
No, I didn't.
how do I get a hold of knowing what I have to do for testing?
No, I didn't.
So you just kind of been floating around without doing anything that you're ordered to do. You left your backpack on there with the important papers that you received. And they were important enough, but you didn't think they were important enough to contact on-site to get redirection again for testing.
I guess not.
Your Honor, on the 17th, he was also positive for THC and refused to send it to the lab. He signed a form, the denial form, but he had the option to send it to the lab to check the levels. And he refused.
January 17th?
January 17th, yes.
I know. I didn't complain.
I'm sorry, it's my understanding that he indicated that he did test on the 17th.
January 17th.
Correct, he did test.
All right.
And he does a positive for marijuana.
So I'm not aware of that. There's been no number sent on this,
I
but
just found out about it myself right now too.
say drive. And then he was informed, I guess, according to the witness, that he was notified of this, but denied something, I don't know what. Yeah.
Confirmation, Mr. Fakori stated that Mr. Shelli was informed he tested positive for marijuana, had the opportunity to have to set out for confirmation.
Okay.
And declined that.
All right.
Is what Mr. Fakori testified to.
Okay.
I did not have it, Your Honor. I was only given a paper for the denial, and I had nothing about a lab in there because I would have never denied that whatsoever.
Well, then what did you deny?
They had sent me a thing and they wanted me to sign a paper saying that I was admitting to using THC, and I said, well, I'm not admitting to that because I'm not using it. So they gave me a one that said a denial thing, and then that was all I got from that point on for anything.
Sir, do you read what you signed?
I didn't read the paper. I just read.
Why are you not reading it?
Because it just said denial for THC. There wasn't much on the paper to read.
Your Honor, when somebody tests positive, we have two forms. One that they can admit to use and one that they can deny use. And they always have the option of sending it out to the lab to get confirmation so that we have a number, a level that when they come in next time, if they're positive again and it goes out, we can check the level of it and check the ratio to see if there's any new use.
Sir, you didn't have any money, so you just left in December?
That's what they told me to do.
You didn't contact in here to say, hey, excuse me, I tried to go test, but I didn't have any money.
Yes, and then they told me to go back when I had the money. The lady in the probation department, as I went back when I had the money, but then I couldn't go because I of this situation I explained to you, and then I came back and I said, you switched over for me, and I went right after that.
Okay. All right, well, all right, thank you, Mr. Pecori. Any other questions, Mr. Goldclaw?
Yeah.
All right. All right, thank you, Mr. Pecori.
Thank you, Your Honor.
All right. The court does find that your client did not test as ordered on December 4th. In court's finding your client guilty for probation violation. As to the sentencing on that, the sentencing.
You said probation violation.
Violation.
That's what I fine.
Yep, okay. So as to the sentencing counsel, you had an opportunity, the PSIs, that there were some corrections that I made note of on January 15th.
That is correct. Excuse me. First of all, he indicated that there were 2 warrants outstanding. It's my understanding that he has, like, they have been taken care of as well. Second of all, Your Honor, there was the change. It is not his girlfriend, but it is his wife. I believe that, but years. Been married for 10 years.
Right, no, I mean, that changed. I mean, a few changes. I mean, the change that, that it's not his girlfriend, but it's his wife, and it's not his girlfriend at 13 years, his wife at 10 years.
That is correct, Your Honor.
And that, his weekly income, we have the word income in there. And then, also, those were the changes.
That's correct, Your Honor.
Yes, and what the original preference was going on. So I had to have that in there, but, yeah. Were there any other medical issues that were missed? I mean, any other corrections that were missed?
Your Honor, only that, and as he has indicated to you, and indicated on numerous occasions, his last conviction was in 2018, approximately 7 years ago. That was a false pretense. Over this last period of time, over the last number of years, he has turned his life around. He's gotten more involved. He's got a good job, as he's indicated. He's working presently at the USW, Local 1082. He apologizes to the company.
Steelworkers? USW?
Yes. Another recommendation, and because he did have quite busy to that time between 07 and 18. As he's indicated, there was a great deal of involvement with respect to his brother. He has lost his brother to drug. He has lost other members of his family. I think, Your Honor, that incarceration is not the appropriate way at this point in time. I believe rather that he should be placed on probation, make sure he gets through this probationary period so that he can continue to show to this court the steps he's taken to turn himself into a good father, to make sure that he's going to be a law-abiding citizen for the rest of his life. Incarceration, obviously, at this time, it would end up at the cost of the plant. I don't believe he has enough time to check.
I would lose my job. That would be helpful.
All cards on the table right now, Mr. Trolley. If you're testing it right now, what's in your system?
So the only thing I can think of that would possibly be there is still a THC, and it's only because my wife still smokes. And I've never told her.
Okay.
No, hold on.
And that's the only thing.
Do not
Sorry.
mistake me for somebody that's going to believe that.
Okay.
Because there's been much testimony from the lab that testifies on a regular basis in this court
Cringe.
that is not a way that you're going to be testing positive
Okay.
for marijuana.
Okay. That would be the only thing that would possibly be in there. That is it. I promise.
Sir, when's the last time that you used marijuana?
I used it to help sleep about a week ago. Because I used it to help me sleep.
Stop with the excuses, please. Stop with the excuses, okay?
All right.
Do you have a medical doctor that you have a bona fide treating relationship with that is recommended that that is the medicinal
Yes.
path for you?
When it became.
Yes or no?
No.
Okay. So you were arraigned in this court in November, correct?
Yes.
And what did this court order as relates to alcohol and drugs that are not prescribed?
Should not use them.
Okay, so you don't have a prescription for marijuana?
No,
No, you don't. So you shouldn't be using it, sir. You shouldn't
when
be
it
using it.
became legal, my doctor told me that I no longer needed a medical marijuana license or.
Sir? Before you became under the jurisdiction of the court, sure.
Okay, all right, I'm sorry.
However, no, because back even in November, I believe that that was addressed with you as well. If not November, then December, because then you said that your marijuana levels would be low, if at all, because it would still be in the system from the arraignment date. So I know I was very clear within the event that you need it for medical purposes, what the requirements are.
Yes.
Okay,
So-
now we're into February and you haven't submitted anything from a doctor that you have a treating relationship with. Not a random doctor that you walk into a clinic and you don't have a treating relationship with.
My family doctor, yes. I could, so if I can get proof from my family doctor that I once had a medical marijuana license.
No.
Oh,
Why did
No.
you just say?
What did I say? What I said was, sir, please listen to what I'm saying, okay?
okay.
You're stating that you need marijuana for medical purposes and that that is the medicine that needs to be prescribed for you, right?
Yes.
Okay, so then you need to get something from your doctor that tells you that the marijuana is the medicine of choice that that doctor is recommending.
I understand.
Based upon what your medical issue may be. Just as though you have a doctor that gives you medicine for high cholesterol, high blood pressure, whatever it may be, diabetes.
I understand.
Okay, and you go back to that doctor on a regular basis to make sure that that medication is in fact working.
Yes. I
Okay.
in fact have my doctor write me something that will say that, yes.
How often do you see your doctor?
I see him every month. I've been seeing him since I was 19 or 20 years old.
Okay, then make sure, please, that when you're communicating with your doctor, that you let your doctor know that you use it on a daily basis.
Okay.
Okay,
All right.
because I have some concerns that you're supplanting one addiction with another, because there is such a thing as marijuana dependence. Okay, so that is why there needs to be something from your treating physician
Okay.
as that's the best medication choice that your doctor is recommending.
Okay. I will do that. I will go there today or tomorrow, whenever you can get me in there. I'll call.
Okay, well, just so you know, sir, I'm presuming that there's gonna be future bond violations.
No, yeah. I promise you.
Based upon the testing that you've been doing and that you've been testing positive for marijuana.
Okay.
So, yes, there's going to be some bond violations coming forward, I want to presume. And please, sir, do not tell me that you would be testing positive because your wife still smokes.
Okay, Your Honor, I'm sorry. I apologize.
Because that really, really lowers your credibility.
Okay, I'm sorry, Your Honor.
Here's the court's for today. The court, after hearing from Mr. Shelli, hearing from counsel, reviewing the report, the recommendation, the criminal history, the court's going to give you an opportunity, sir, and the court's going to find that there is reasonable grounds to talk MCL 769.5. The court's going to order 12 months probation. You're eligible for early discharge. I'll go over that in just a few moments. The court also finds that the following sentence is in the best interest of justice, is reasonable and proportionate to the circumstances of the matter and Mr. Shelli, keeping in mind the guidelines for the legislative guidelines and the intent on those. Correct, you're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer if that your probation officer may require, in person, writing, or virtually. You notify probation officer immediately by change of address or employment status. You are to not use any alcohol or drugs. You are to be subjected to random testing. You're going to be continuing that. The court's going to also order you, sir, to participate in outpatient substance use counseling. The rehabilitative goal for the random testing is the court can monitor your progress and in the absence of sobriety. Do you have an issue with participating in that substance use counseling, sir?
No, ma'am.
No, we were just discussing to make sure that abide as sex, you know, the marijuana aspect, just making sure.
The rehabilitative goal for the outpatient substance use counseling is so that you can learn additional coping mechanisms and perhaps address the line use disorder as well. So the court's going to order you to participate in can meetings once per month for rehabilitative goal for that condition, just so you can get additional support services and recovery resources to help maintain sobriety. Any questions regarding any of that?
Lower cut.
As to the bond violation, the court's going to order 10 days jail. We want to suspend that jail. If there's a probation violation served, that jail is back on the table.
I understand.
So whether you serve that jail time, 100% on you.
I understand.
As the fines the cost, the court's going to order a $400 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that can be waived. $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. So that's a total of $1,525. You did post a bond of $500, sir. That's in your name. Do you have any other money to pay today?
Unfortunately, Your Honor, I don't. They just paid off those tickets that were $700. So unfortunately, my check is a little short right now.
So, sir, so no, you do not. That's fine. I was trying to determine after we apply your bond, what the balance will be. That's all that's the only reason I asked, sir.
right.
So that means your balance, we're going to apply your bond, $500 balance. I'm sorry, $500 bond is applied. Means your balance of $1,025, keeping in mind that you may not have to pay back $300 back. So how much can you pay per month and what date of the month works best for you, sir?
150 a month.
No, Your Honor, I'm going to suggest that eat $100 a month. And then because of the possibility, I'm just saying.
No, counsel, I'm not smirking at you. I'm smirking at your client because he's shaking his head no as you're
Well,
talking.
because I want to get it off as fast as I can. So
Hold on.
Listen,
What he was trying to say is that keeping in mind you could pay more if you could pay more. But
thank you.
sir, you're very quick to be very defensive and no, instead of listening and waiting for the rest of the conversation. Okay?
Thank you.
You're welcome. So, we'll do $100 a month. If you can pay more, sir, you can certainly pay more. We don't have a prepayment penalty.
okay.
Okay?
Sounds good.
So that'd be like a mortgage.
What date of the month works best?
Probably the middle of the month. So if like it's 15th or 16th, somewhere around there.
Okay. So since we're approaching the 15th or 16th, are you expecting it's going to be this month or next month?
I can pay $100 on Wednesday. Next Wednesday.
Okay, the
And
19th.
then start from that point on.
Okay, so let's do beginning February 19th. And the 19th of every month thereafter, okay?
Sounds good.
All right, sir. As I did state, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made good faith effort to remain in full payment. I know it went very quickly on that part, but probation will go over there with you again.
Okay.
All right? Good luck to you, sir.
I have one question, please. Is when it relates to the $100 a month, though, if I happen to be able to make a payment for more money, can I pay like twice in 1 month?
I will explain.
All right.
Yes.
Thank you.
Thank you.
Good luck to you, sir.
All right. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.